Secretary Noem, let me turn to my final topic. In a filing in federal court this week, the Justice Department said that when the administration was ordered back in March to stop sending detained migrants to a mega prison in El Salvador, you personally made the final call to continue the flights anyway. Is that correct?
They got that order to stop sending, and they stopped sending. But the written order was not to bring people back. So they didn't bring people back. They didn't violate the order to stop sending. They're making it sound like there were new flights that were sent after the White House received the written order to stop sending people. That's not what happened. There were flights already in the air. They had been sent. Past tense.
Did you defy the court's order, Madam Secretary?
No, Kristen, and that's one of the things that we continue to face across this country is activist judges who are using radical decisions that have no standing and no grounds to try to stop what President Trump is doing to protect America.
Boasberg is literally, he's goading, he's challenging this administration and these Republicans in Congress and the Senate to impeach him. I mean, he's acting in an absolutely partisan, politically machinating, childish, completely feckless manner, unsuited for the bench. This is exactly the kind of thing that Article 3 had in mind when it required that federal judges hold their office during good behavior. Judge Boasberg is actively being held in bad behavior.
Can President Bukele weigh in on this? Do you plan to return him?
Well, I'm supposed to be suggesting that I smuggle a terrorist into the United States, right? How can I return him to the United States? Like I smuggle him into the United States, or what do I do? Of course, I'm not going to do it. The question is preposterous. How can I smuggle a terrorist into the United States? I don't have the power to return him to the United States.
But you could release him inside El Salvador.
Yeah, but I'm not releasing. We just turned the murder capital of the world into the safest country of the Western Hemisphere, and you want us to go back into the releasing criminals so we can go back to being the murder capital of the world? No, that's not going to happen.
So let me explain in a nutshell what's actually going on here. They had a hearing early on. This is about the Tren de Aragua, the Alien Enemies Act proclamation by Trump. Said Tren de Aragua, Venezuela he did an Alien Enemies Act proclamation, which allows him to summarily deport designated alien enemies, which were in this case Tren de Aragua, gang members from Venezuela. I won't go into all the details of that. I've covered it many, many times. And so they had gathered up a bunch of Tren de Aragua guys, put them on a plane, and the plane took off. And then they had a bunch of other Tren de Aragua guys not yet in the air on a plane, and they got lawyers, and they went to Judge Boasberg and said, hey, we want a habeas hearing. We want the government to justify why they're holding us. Now, a wrinkle here was all these guys were being held in Texas. And Jeb Boasberg is not in Texas. Jeb Boasberg is an unelected black-robed, tyrannical, inferior district trial court judge in the D.C. district. So he never had jurisdiction of this case. If you want to bring a habeas hearing is, I demand the government explain in court why they're holding me. But by law, that argument has to be made where they are holding you, in Texas, not in the District of Columbia. But of course, all these left-wing lawyers, they live in D.C., so they know they're going to get a more favorable judge in D.C. than they're going to get in Texas, where the terrorists were actually held. So they went into Judge Boasberg's court. And Boasberg holds a hearing that goes on for hours of the lawyers for the terrorist arguing, and hours of the Trump administration arguing, and the Judge Boasberg asking questions, supposedly in good faith. And so these discussions are going back and forth. And like any discussion or argument or any meeting you've ever had in a company where things are being fleshed out, lots of things are said in the course of the conversation as facts are developed, information is developed. And in this particular case, at one point in that conversation, Judge Jeb Boasberg said, hey, if there are guys on planes, like you say, I want those people returned. So they're within my jurisdiction. The guys in international airspace on airplanes. That was something he said in the course of this discussion. And then the discussion continues for much more time. And at the end of all that discussion, Jeb Boasberg reduces his order. At the end of that meeting, he reduces his order to written form. And in the written form of his order, it says nothing about turning planes around and returning people to the U.S. Nothing. Now, most court orders are written. They're written for purposes of clarity. Some court orders have to be written. A temporary restraining order or a preliminary injunction has to be written by court rule. It has to be written down so that the parties being enjoined have absolute clarity about what they're allowed to do and not allowed to do. And they know with clarity if they do certain things, they could be held in contempt of court because it's explicit and detailed. You can't have a vague injunction, just verbal, and no one really understands or recalls, or there's a dispute about recollection. It needs to be in written form. So what Boasberg did is in the course of hours of discussion, debate, and argument in his courtroom, in the midst of that, he said, hey, I want these planes turned around. But when he finalized his order, after the end of all the discussion and debate and argument, when he finalized his order into written form, it said nothing about turning the planes around. And a reasonable understanding of this proceeding is that lots of things might have been said in the course of the discussion, but the final written order is the result of the totality of the discussion, where people's thoughts are clarified, the facts are all put on the table, all the arguments have now been made, it's over, here's the written order. And the White House followed that written order to the letter. Now, the written order didn't include anything about turning the planes around. By the way, the White House also appealed the written order all the way up to the Supreme Court. And the Supreme Court said, hey, Judge Jeb Boasberg, you don't have jurisdiction here. Everything you've done has been without jurisdiction, without authority. Your oral orders, your written orders, all of it is without legal authority. According to who? According to the Supreme Court of the United States, Jeb Boasberg's ultimate bosses. So Jeb Boasberg, of course, said, well, I accept that ruling by the Supreme Court. But until that ruling was handed down, my orders still are presumed to have lawful effect and you disobeyed them. So I want to hold you in contempt. And the White House argument all along has been, listen, we followed your order. We didn't disobey your order. Your written order was the final order as we understood it. You could have included in that written order, turn the planes around, but you didn't. So we didn't turn them around. You think Boasberg did this by accident? Remember, Boasberg is the same judge who at the judicial conference after Trump's election, but before Trump was sworn in, at a judicial conference where Chief Justice John Roberts was present, Judge Boasberg said, hey, I got a question, Chief Justice Roberts. What do we do when Trump starts disobeying our court orders? And then Boasberg lays what is obviously nothing but a trap for Trump and his administration. He knows damn well Trump's going to follow the written order to the letter. So he deliberately fails to include in that written order things he said verbally in passing in the course of a multi-hour hearing. And then he says, well, you should have followed the oral order too. You should have just understood that I wanted all that and everything in the written order to be followed. No lawyer would believe that to be the case. They would say, all right, we had this hours of discussion. The judge distilled it down into a single written order. We're going to follow that written order. Not every passing remark in the course of a multi-hour hearing that was not included in the written order. Obviously, this was just a trap by the feckless Judge Boasberg. And of course, part of the trap here is not just that he failed deliberately, I would suggest, failed to include in his written order things he said in passing to set a trap for the Trump administration, knowing they would follow the written order to the letter and consider anything not included in the written order as having been laid aside and no longer to be followed. But of course, this provides a narrative for the mainstream media to cover. They get to have Kristi Noem on their Sunday shows and say, didn't you fail to follow his order? And Kristi Noem says, no, we followed the written order, the final order. We followed it to the letter. But isn't it true? If his orders were not followed, isn't that your responsibility? She says, yeah, it was my responsibility. So you didn't follow the order. No, we followed the order. Let's listen to this kind of exchange.
Secretary Noem, let me turn to my final topic. In a filing in federal court this week, the Justice Department said that when the administration was ordered back in March to stop sending detained migrants to a mega prison in El Salvador, you personally made the final call to continue the flights anyway. Is that correct? Do you acknowledge that?
You see how they phrase that? Let's listen to it again.
When the administration was ordered back in March to stop sending detained migrants to a mega prison in El Salvador,
So they were ordered to stop sending. That's accurate. And when they got that order, of course, they appealed it. And Boasberg's jurisdiction was nullified. Lack of jurisdiction, I should say, was identified by the Supreme Court. They got that order to stop sending, and they stopped sending. But the written order was not to bring people back. So they didn't bring people back. They didn't violate the order to stop sending.
Personally made the final call to continue the flights anyway. Is that correct? Do you acknowledge that?
To continue the flights anyway. They're making it sound like there were new flights that were sent after the White House received the written order to stop sending people. That's not what happened. There were flights already in the air. They had been sent. Past tense.
You know, we have court filings going on and decisions that are going forward. I'll let them continue to play through that process.
But did you make that
I'm
call?
proud of President Trump and his leadership and the decisions that we have made and the decisions that are made on.
Did you make that call? This question is based on the false premise that a court order was violated.
Deportations, where flights go and when they go, are my decision at the Department of Homeland Security, and we will continue to do the right thing and ensure that dangerous criminals are removed.
So that you're saying that it was your decision. It sounds like the judge wanted to ensure that people were given due process. He said very clearly, quote, any plane containing these folks that is going to take off or is in the air needs to be returned to the United States. But those people need to be returned to the United States. However that's accomplished, I leave to you. But this is something that you need to make sure is complied with immediately.
See, that was what he said in court and did not include in his written order. The final written order.
Did you defy the court's order, Madam Secretary?
No, Kristen, and that's one of the things that we continue to face across this country is activist judges who are using radical decisions that have no standing and no grounds to try to stop what President Trump is doing to protect America.
Now, in fairness, why can't Kristi Noem simply say what I just said? Why is she ambushed by this question? I don't understand this. Why can't she simply said lots of things were said in that hearing, and then they were distilled into a final written order, and we followed that final written order to the letter. And it did not include returning planes to the U.S.
to keep us safe. So we'll continue to do the right thing, continue to work and protect Americans, no matter what radical judge comes out and tries to stop us. We'll do the right thing and know that we're on the side of the law, the side of the Constitution, and the side of the American people.
I mean, that's all very 30,000 foot. Sounds nice, but why can't she simply state the practicality? We had a long hearing. At the end of that hearing, the judge gave us a written order. We followed that written order to the letter. There was no violation of any order. Fortunately, the people writing for Kristi Noem are smarter than her. Ben Shumate is the lead attorney on this. Defendant's response to the court order. So we're talking here. Let me pull this document up. Now Boasberg last week is holding hearings. And of course, the hearings are to determine, he says, I have to make a decision whether or not to refer Kristi Noem for criminal contempt charges to the Department of Justice. Who thinks the Department of Justice is going to do that? So he's not doing this for that actual purpose, his claim purpose. He's doing it just to create havoc. Because one of the things he's going to do is order people, like the entire Trump administration from the Department of Homeland Security will be ordered to appear in his courtroom and provide testimony. He's pretending he's just thinking about that. He's not actually going to do it. He's pretending that, well, they can just submit written declarations about what they knew, what they understood the order to be. But he's doing all of this to inconvenience the Trump administration as much as possible and provide as much narrative fuel to the legacy media, TDS media, as he possibly can. So while he's holding all these hearings saying, hey, I think you guys should be held in criminal contempt, here's the response. Here's the response from Ben Shumate at the White House, one of the lawyers for the Trump administration. Defendant's response to court order. So this is the Trump administration response. This court of Jeb Boasberg, the unelected black-robed tyrannical inferior district trial court judge Jeb Boasberg, has directed the parties to propose next steps for its inquiry into potential referral for criminal contempt. The Trump administration respectfully submits that no further steps are warranted. As defendants have previously explained and reiterated below, in other words, we've already explained this to you, Judge, including to a Court of Appeals panel, and as Judge Katsas agreed in his concurring opinion on the panel, so it was a 2-1 vote favoring Trump, And one of those two judges that voted for Trump also added that there was no order violation here because the written order, the final order, was followed to the letter. The Trump administration did not violate this court's order. Defendants stand by that legal position. Their interpretation of the court's order is correct. And at minimum, their interpretation is reasonable and therefore not grounds for contempt. Insofar as this court, as Jeb Boasberg, continues to disagree, defendants identify below the officials who made and advised on the decision not to recall the flights already in the air, which is the only remaining information necessary for this court to proceed with a referral. If the court believes any further information is needed, we respectfully request an opportunity to provide that information by way of declarations. In other words, sworn statements, written statements that can be sent into the court, as opposed to having senior administrative officials have to come into court to testify. Even the terrorist lawyers agree that declarations, written declarations, are appropriate. They go over the facts here. At approximately 6:45 p.m. on March 15th, by the way, you think federal courts are normally working at 6:45 p.m.? Jeb Boasberg orally directed counsel for the government to inform his clients of the court's oral directives at the hearing, including statements directing that any removed class members need to be returned to the United States. By that point, 2 flights carrying individuals designated under the Alien Enemies Act, TDA terrorists, had already departed from the United States and were outside United States territory and airspace. At approximately 7:25 p.m., the court memorialized its temporary restraining order in a written order. So temporary restraining orders and preliminary injunctions, as I said earlier, are required to be in writing for purposes of clarity. Because if you violate a TRO or preliminary injunction, you can be held in contempt. So in order for due process to apply, there has to be clarity about where the line is that you might cross and be held in contempt. It can't be vague and ambiguous. TROs, preliminary injunctions, permanent injunctions have to be in written form. So the court did. The court memorialized its TRO in written form, as the court, during the oral argument, had said it would do, told everybody, listen, at the end of all this, I'm going to give you a written order. That's what everybody's waiting for, the written order. The written order enjoined defendants from removing class members pursuant to the Alien Enemies Act. The written order, the final order, after all the argument and debate, unlike the oral directive, said nothing about returning class members who had already been removed. The Deputy Assistant Attorney General promptly conveyed both this court's oral directives and its written order to DHS. Deputy Attorney General Todd Blanche and Principal Associate Deputy Attorney General Emil Bove, who's now been made a Trump-appointed judge, by the way, I think on the D.C. Circuit Court of Appeals, if I recall correctly, provided DHS with legal advice regarding the court's order as to flights that had left the United States before the order issued. Through DHS Acting General Counsel Joseph Mazzara. Mazzara then conveyed that legal advice as well as an own legal advice to Kristi Noem. After receiving that legal advice, Kristi Noem directed that those detainees who had already been removed from the U.S. before the court's order could continue on in their flight to El Salvador, the tropical prison resort of El Salvador. As explained below, that decision was lawful and was consistent with a reasonable interpretation of the court's order. Absolutely. So, might the judge feel like, well, you know, what I meant to say is I meant to include in the written order that the planes have to be turned around, but he didn't. That fault is on the judge. Or what I think more accurately happened here, this judge intentionally said things in oral directives and then intentionally did not include them in the written order to lay this trap for the Trump administration. Although the substance of legal advice given to DHS and Noem by their lawyers is privileged and doesn't have to be explained to the court, the government has repeatedly explained in its briefs, in its previous arguments to this court and on appeal, why the Trump administration's actions did not violate the court's order, much less constitute contempt. Specifically, the court's written order did not purport to require the return of the terrorist who had already been removed, and the earlier oral directive was not a binding injunction. It wasn't written, It's especially not binding when it's followed by a written order that any lawyer would properly understood displaced what might have been said in passing during the hearings. Judge Katz's opinion, this was the concurrence in the D.C. Circuit's grant of mandamus relief. Again, mandamus is when a higher court simply orders a lower court to do something. It's almost unheard of, except in this age of Trump where the lower courts are being so tyrannical. Normally, the Court of Appeals would say, hey, listen, trial judge, we think you made a technical error of law here. You applied Rule A. You were supposed to apply Rule B. We're going to send the case back to you so that you can apply Rule B and get the correct outcome. We're going to give you another shot at this. That's normally how it works. A writ of mandamus is not that. A writ of mandamus says, we don't trust your judgment on this. So we're just going to order you what to do. We're going to order what the outcome is here. We're taking this away from your discretion. So that appellate court granted to the Trump administration a writ of mandamus relief against Boasberg. Part of that explains the plain language, legal context, and the court's first TRO all support the government's narrower reading of the second TRO as keyed to physical expulsion from United States territory. You can't keep removing people, not to turn people around who had already been removed. First, the plain meaning of the word remove connotes physical displacement, not transfer of custody. Second, statutory context reinforces this understanding because the Alien Enemies Act itself repeatedly ties removal to physical expulsion. The Immigration and Nationality Act likewise supports an understanding of removal to mean the physical expulsion of an alien from the United States crossing the border. Third, this, which had already happened with the terrorist on the plains. Third, this court's earlier TRO was expressly territorial in focus, suggesting that the word removal in the subsequent TRO was similarly territorial. For all these reasons, the court's written order did not enjoin the government from transferring custody of the detainees who had already been removed from the U.S. before the issuance of the order, or otherwise require their return. As appellate court Judge Katz has further explained, Boasberg's oral directives at the TRO hearing were inconsistent, garbled, and if read in isolation were indefensible to the point that this court, Boasberg, itself declaimed at least two of its own oral commands in later opinions. All of that confirms that it was appropriate to construe the written order as having superseded any prior oral directives, even assuming that the oral directives can ever be binding, which it can't, because a TRO or an injunction has to be in writing for purposes of clarity. Continuing with Brett Shumate, in short, the government's territory-based interpretation of the TRO rests on written, conventional, and publicly available sources for construing that binding legal text, while the competing interpretation rests on generalized appeals to the purpose of the TRO, including having to read the mind of the judge, as well as fine parsing of the court's statements at an oral argument, the transcript for which was unavailable until after the claimed contemptuous act had already occurred, and the substance of which the trial court never reduced to writing or later disclaimed in significant part. Accordingly, the government maintains that its actions did not violate the court's order, certainly not with the clarity required for criminal contempt, and no further proceedings are warranted or appropriate. Indeed, the mere fact that Judge Katz agreed with Trump's interpretation of the TRO means that the order could not have been so clear and decisive that it left no doubt about what was required as criminal contempt requires. Nevertheless, insofar as this feckless, unelected, black-robed, tyrannical, inferior district trial court has inquired into the identities of the decision-making officials for the purpose of making a potential criminal referral, the actions were taken by DHS through Secretary Noem after being formally advised about compliance with this court's order by both DOJ leadership and the acting general counsel of DHS. The Trump administration does not believe any further facts are relevant to this court's potential referral, but if the court determines otherwise, defendants request an opportunity to provide such information by way of declarations, sworn written statements that can be done in their office and sent into the court. No live testimony is warranted at this time. Defendants object to the involvement of plaintiffs in these collateral proceedings. In other words, the terrorist lawyers are still involved here, but they have nothing to do with this contempt issue. This contempt issue is between the court and the Trump administration. The plaintiffs have no role here. So Trump objects to the involvement of the terrorist lawyers in these collateral proceedings because criminal contempt concerns the dignity of the court. It no longer involves the original litigants as the parties of interest, and the terrorist lawyers thus lack standing to participate as anything other than fact witnesses called to testify. It would be inappropriate for an interested party to essentially be conducting a criminal investigation on behalf of the court, meaning the terrorist lawyers, to be conducting a criminal investigation. So they don't want the terrorist lawyers, for example, if Kristi Noem is compelled by this judge to come into his courtroom and take the witness stand, they don't want her subject to cross-examination by the terrorist lawyers, is what they're saying. So that is the truth and reality of the supposed claims of Kristi Noem disobeying a court order. A big part of all this, of course, is simply that it's part of the narrative that they've been pushing all along, that everything Trump does that they don't like is unlawful. If he's doing things that are unlawful, you don't have any obligation to obey him, whether you're a military official or anybody else, a member of the intelligence agencies of the United States. They're trying to paint him as a lawless president whose orders need not be obeyed. And Boasberg has decided to move forward with the contempt hearings. So he says, right now, I'll accept these written declarations. And after I read those, I'll make a decision about whether I'm going to demand that Trump administration, high officials, officers under the Constitution will be called into my courtroom to testify on all this nonsense. That's where we are with all of that.